Hey folks, Denise Howell here, and you're about to listen to This Week in Law. This week I'm joined by Alex Marcham and Matt Curtis. We'll have a design patent palooza, discuss whether GDPR will topple ad tech, and AI music will soothe the savage beast. All next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CacheFly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, Matt Curtis, and Mike Keys. Episode 423, recorded May 18th, 2018. Cookies for Privmas. Hi, folks. I'm Denise Howell, and you're joining us for This Week in Law. I'm very excited that you're all with us here today. Per usual, we have a great panel of folks to discuss the interesting developments that have caught our eyes and our attention at the intersection of law and technology. Love to introduce them to you right now. Our guest this week is Alex Marcham. He works in the networking industry, in engineering, system architecture, has experience in marketing and product management, and has been a fan of the show and emailed me to let me know that partly, at least, as the result of participating in the This Week in Law community, he's going to go on and go to law school. I'm so excited about that, Alex.
Yeah, I'm just keeps getting more and more interesting by the week. I'm not sure exactly when I'm going to do that, but it's on my list of things to do, and just keep getting more interested by the day about how things like internet law and patent law shape all these systems and things that make our modern world work. So thanks to everyone in the TWiL community and yourself for the show, and I'm sure it's helped a lot of other people like me as well.
You're not the first person who's let me know that they've decided to pursue a legal career as the result of listening to our show for a long time. So that's wonderful. I'm thrilled to know it, thrilled to meet you. Also here is someone who could tell you a lot about being in law school. Matt Curtis is slogging through that right now in South Bend, Indiana at Notre Dame. Hi, Matt. Congratulations on finishing finals.
Yeah, it's very exciting. And I can attribute to Denise was not why she wanted to go to law school, but certainly a good vetting criteria of like, can I be not as lame as possible and still be a lawyer? So you helped me pass that bar. And then, but we had my brother got married. What's that?
1 second. I was going to say that's now the official slogan of This Week in Law. Not as lame as possible. I'm putting it on t-shirts right now.
Marketing genius right here. But yeah, my brother got married last weekend, and I, until Wednesday, I thought I was a really good dancer, and then I saw the video. So that wasn't great, but otherwise it was a fantastic wedding, and hated to miss last week, but we had a great time.
That's wonderful. Congratulations to your brother too. That's so exciting. I understand you're going to be switching venues shortly.
Yeah, so I mentioned a company that we're operating a couple times, but we raised some early funding, and we're heading out to San Francisco to go see if we can make it work and do the whole startup thing. So very excited.
That is really exciting. We're going to definitely have to pick your brain about that process as you go through it. There's a lot of legal overtones we could go into.
I text my attorney almost daily, and he puts up with me, so it's really nice.
Right. Well, we're going to dive into talking about some substantive legal stuff, as we do most weeks here on This Week in Law, almost all of them actually. But I didn't want to launch into the show without acknowledging, I wish this were the first time we were starting and doing a show while elsewhere in the world there is news breaking and live updates unfolding about some terrible tragedy. It's definitely not the first time that we have found ourselves in the position of doing the show while these updates are unfolding while we do our thing. Those of you who are listening with us live, I'm sure, are going to also be paying attention to the fact that there has been a shooting this morning in Texas at Santa Fe High School, where last I saw, and I've been now turning my attention away from that for a little while here to get ready for the show, but 8 to 10 students or people were dead, most of them students, and the law enforcement and crisis responders are there on the scene trying to deal with the fact that not only was there a shooter, but apparently they have found explosives in the area, and it's just, awful, 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 and we're definitely, personally, I'm just torn apart about it. We're going to go on with the show, of course. We have a lot to talk about, and a lot of people don't listen to the show live, so won't be watching, won't need to worry about what's going on in that crisis while they're participating in the show. But I just wanted to acknowledge that we know that that's going on, and urge everyone within the sound of my voice and who listens to this show to show kindness and respect and help and listening to all your fellow humans, and to be vigilant about fostering and passing along those values to everyone you know, because we're just hearing way too many of these kinds of things happening. This is the 22nd school shooting of the year in the United States, and it is only May. So really disturbing stuff, but we're not going to let it derail what you came here for, which is technology law. So we're going to start out talking about some design patents. All right, who remembers when the first lawsuit, the first legal scuffle between Apple and Samsung began to take place? Anyone know the year?
Is it 2011?
Very good. Yes, I'll take 2011. Exactly.
Hey.
That's when the lawsuit was filed by Apple, claiming that several of Samsung's phones infringe several of Apple's iPhone patents. So here we are in 2018, and this lawsuit is still an active, viable lawsuit. It has gone all the way to the United States Supreme Court on primarily the issue of damages, how the parties calculated the damages. A jury of 9 people found in the trial, which I think was in 2013, I want to say. Oh no, it was in 2012. Anyway, a jury found that Samsung had infringed several of those patents. And so really everything that has gone on since then has been about what that means and how much Samsung has to pay as the result of the infringement that was found. We're talking, Apple has asked for numbers in the billions. So far, Samsung has paid hundreds of millions. Actually, I'm not sure that, I think they did actually pay the money, even though this is all still underway. The trial that starts next week on Monday in Northern California is about clawing back some of the money that has been paid. And the reason that Samsung gets to have this trial and try and claw some of its money back is the U.S. Supreme Court issued a decision critiquing how the damages were calculated here and kicking it down to the lower courts and saying if what has happened is an infringement of a minor part of a patented device, you can't calculate the damages based on lost sales of the whole device. So that's what this trial is going to be about next week. It will be about the standard that's used for calculating those damages. So it'll be interesting to see, and certainly has broad ramifications across the technology world, how the court comes out and whether this now becomes, going forward, the standard that will apply in other similar cases. The analogies people use are, for example, if you have the patent on a cup holder in a vehicle and someone has that patent, and you're found to have infringed on that patent, do you then have to pay them the entire cost of the lost cost of the vehicle as the result of your infringement? Just about everybody hears that one and goes, yeah, no, you don't have to do that. Other analogies would be if you have a patent to an icon that appears on a phone screen and someone is found to have infringed that, or do they then have to pay you for the entire replacement value, lost sale value of the phone? So I'm going to kick this over to you guys. Alex has some experience in the past in the design patent arena. Why don't you tell us, Alex, about your background in that area?
So mine is kind of, from an engineering standpoint, looking at, say, a product that we'd be developing, saying, would this be able to actually be able to brought to market because it in some ways is similar to, X product from X competitor, whether, not by design, but because certain, aspects of the design are obvious to someone who is skilled in the art, and therefore is that patent valid? All those kind of general issues. So not really like, patent litigation or anything like that, but more so from an engineering standpoint of kind of an initial analysis of, is this practical at all to do, or are we setting ourselves up for a failure kind of thing? I think that you mentioned the standard of what's it called to there's a phrase that they use to say the whole manufactured article. What's the phrase I'm looking for?
Matt, do you remember? It's the test that the Supreme Court considered in this case. I can find it in one of our links here. Hang on. Soldier on, Alex, and I'll find the name.
I'll just throw you a curveball there.
No worries. It's in here somewhere. Article of manufacture. There it is.
That's the one. And I just think that this case in particular, as well as some others, really show off, I think, how antiquated the current patent system is. Because I think with how complex these modern products are, if you think of how many parts, including design and then actual component choice and aesthetics and user interface and software and all these other things that are within a single, smartphone today, I think that a single test to determine that article of manufacture just seems too complex and would just lend itself to never-ending litigation, which is really what's happened in this case, I think. And I don't think that this really matches kind of the spirit of the patent system and the ability to make a marketplace of innovative products and things that inventors can protect. It will never cease to amaze me, for example, that Apple got a real patent for a rectangular device with rounded corners and a screen on the front. Which they had for the iPhone. I think that one's since been invalidated, but they did have that at some point. And I really agree with Samsung's point here that I think it's too simplistic to say that if one aspect of the design is infringed, then all of the earnings from the entire resulting product should go to that other party. But then you can see the opposite side of the coin that says perhaps that shape, you could argue, if that was one of the patents at issue here, would they have sold half the products they did without that? And I don't really know how you resolve that question except on a very expensive case-by-case basis. Really. Yeah,
excellent point. Matt, I know you are definitely a patent aficionado. Anything you want to weigh in on here as far as this new trial between Samsung and Apple?
Yeah, I think that Alex did a good job of laying out the basic or like the points of this. And my expertise is not in design patent. It's such a trademarky sort of thing because like Alex said, what you're trying to find on the damages point is, okay, we've said the Supreme Court said you can't just have all the damages, which I think makes sense. If I'm infringing, the average patent, the average phone has 200,000 patents. And so if I infringe one of them, you getting the whole damage seems inequitable. And also, so you take that first, but then you say, what is the value of each patent? And so what you really have to make there is what is the economic decision that the buyer in 2009 through 2011 would have made if the corners wouldn't have been rounded on the Samsung phone? it doesn't matter how many surveys you do or how many a purchasing decision, especially when you're dealing with emerging brands, which really the iPhone and the Samsung was like, this was the beginning of the smartphone revolution. We were defining what the look and feel of all these were, and to say that it won because of the rounded edges or like a certain bevel, that's just a really hard thing to do. It's incredibly difficult, like, to historically track how these individuals would have made their purchasing decision. But ultimately, like, that's what equity is asking the court to do. Is asking to say, but for this, for this design, they would have probably designed something else. They would have had a competitive product, but like, what percentage would have been less competitive than it was in the market? So this is these kind of cases are litigators' dreams, because they're big open questions that you just got to bring a bunch of facts and tell a very compelling argument about.
Right. It seems like Apple has been able to do that before in this case. That's why we find ourselves talking about whether Samsung has to pay hundreds of millions or billions to Apple as a result of this. It really doesn't seem like they're going to be able to make too much headway in that determination that they infringed and owed money. But this question of how much money they owe is a really big question, and could, if Apple gets a real home run here on the damages, that's going to have a real chilling effect, equally as much as the fact that they got an infringement verdict to begin with. So definitely one to watch next week. Any final thoughts, Alex?
Not really. I think you guys really hit the nail on the head. One thing that is particularly difficult about this one is that comparing our thoughts on like smartphone design in particular in 2018 to what it was at the time, it's now there's such a commodity item, and it seems so obvious that everything should be this glass 6-inch slab with these different app icons on it, that wasn't obvious at the time, but now we see it so obvious because they're so ubiquitous. So I don't really know how you resolve that to anyone's real satisfaction. Right.
Does anyone, just sort of blue sky fantasizing here, do you think that we're going to see that change anytime in the next 10, 20 years?
Oh, as in the general design?
Yeah. Do you think someone's going to come up with a really innovative design for a phone that's going to seem obvious to us after the fact?
I think so. And I think the best designs seem obvious after you see them, right? You see it and you go, I should have done that, but then you didn't. So,
right.
Like a rollable phone, for example, something like that, I think will probably come along. Some of the flexible display technologies, interestingly, that Samsung's been researching for a number of years. So, those all look interesting. I'd say it's probably inevitable, but I wouldn't hazard a guess as to when.
Right. Well, maybe, we've got this sort of intervening time period where phones are actually something that's separate from us, right? At some point, they'll just be integrated in some way. So
you want the Inspector Gadget kind of hand phone when you pull the antenna around?
Yeah, something like that. So I'm just wondering, does anyone think that a rectangle is a de facto standard that we're going to stick with? What if somebody went round?
Yeah, I'm all for round. I just think that look at 20 years in the future and bet whether technology is going to be the same as it was 20 years ago, and you're probably making the wrong bet. It's inevitable that it's going to change somehow.
Right. I had a phone when I was a little kid that looked like an airplane. Maybe we'll just have airplane phones. And maybe they'll fly. I don't know. Why am I being so silly today? I don't know. You guys will have to rein me in.
I don't need my phone chasing me around the house. I really don't. I don't need
that. Speaking of things that people might think are silly, I thought it would be fun. There is a blog called Patently Apple that if you are interested in seeing all the patent news about Apple, the things that they've been awarded patents in, and they are constantly applying for patents, then this is the blog for you, and you should check in with it from time to time. And I highlighted a couple of entries for our discussion points today. One covers a series of design patents Apple has been awarded that include something called Air Power, which looks like kind of a charging mechanism, I'm thinking.
Probably a wireless charging pad by the look of it.
Yeah, that's what I thought. Maybe it's some sort of power source. I don't know. It's hard to tell just by looking at the design photo here. But you're right. It looks a little like a pad. We've got glass covers, which this is kind of hilarious to me as an iPhone owner who has had to slap third-party glass covers on countless phones. So Apple's now got a design patent on one for the front and one for the back. So, geez, third-party glass cover manufacturers, look out.
With that one in particular, I couldn't work out just from a brief look at the patent whether that was an aftermarket, add-on to the front and back, or whether that was for the glass, because the body of the iPhone X is kind of glass front and back, isn't it? So I couldn't tell whether this was an aftermarket add-on or whether this was the part of the design that is already, bolted onto it when you get it out of the factory.
Gotcha. Yes, I'm not sure about that either from looking at this patent. But interesting. What else do we have here? We've got a leather folio case. Again, that's definitely not part of the phone. Lots of people make leather folio cases.
But not like that one.
Not like that one.
This one just really made me laugh because, like you said, I looked at this and I was thinking, I have one of these. I bought it in 2015 for my iPhone 6 from, Best Buy from somebody else.
Right.
Like,
I still
surely
have one,
this
my
is
Palm Pilot.
Yeah, I mean, this just smacks like, I don't know how you get granted that as a patent. I mean, it just sounds like, something that aftermarket manufacturers will then just have to license to make sure they make licensed, add-ons. But it just, I don't see how that is within the spirit of a patent as intended. Really, I don't.
Yeah, it's interesting. Well, if you thought that one was bad, the next batch of design patents awarded Apple, written up by Patently Apple, includes their building, their store, specifically in China. I'm not going to butcher the name of the city, but it's a city in China, and they have a design to, of course, one of their very distinctive-looking glassed-in architectural styles. Let's see. It has 2 support beams. There's a question of whether a 4-beam store design would be within the original patent granted. So now they have that. Apparently, they now have a 4-beam store design that they have patented. So if you're going to make a glassed-in 4-beam store, you might want to make sure you're not running afoul of the Apple patent. They've got a cover for the MacBook Pro, the backside of the Apple Watch for heart rate monitoring and inductive charging, and a whole slew of other things too. So and also a metal. It's called glassy metal technology, which covers nickel iron, nickel cobalt, and nickel copper glass forming alloys. There you go. So lots
I
of
like the name.
Glassy
metal.
Yes.
That's great.
I like that too. Very, very
just such an
futuristic.
odd. Sorry to interrupt. Just such an odd bundle of patents there, isn't it? It's like the one that really stands out is the back of the Apple Watch. You look at it and it's like this. There's this complex, really nicely integrated combination of like inductive charging and an optical heart rate sensor and all this kind of stuff, and then a building.
Building.
I'm not familiar with how patent law applies to buildings and architecture, but it doesn't doesn't seem like a goer to me.
No, it doesn't seem like a goer to me either. But our patent office is nothing if not often critiqued for the patents that get granted. So the fact that a patent is granted is certainly a good first step, but it's not the end of the line. Patents can be challenged, and I'm not sure. I'm not a patent lawyer, so I don't know the exact terminology, but they can be. The patent office giveth and it can taketh away as well, under the right circumstances. So the fact that something's granted is sort of just a move on that chessboard, and then people come in and say, no, it's a building and that's not patentable. So we'll have to take that one under advisement and see if it remains in Apple's patent portfolio. We have some other patent-related stuff that was interesting this week. There's a lawsuit that's been filed, I believe it is in Arizona, between a company called Nikola and the automotive company you may be more familiar with called Tesla. So we've got both halves of Tesla's name battling it out. Nikola makes alternative energy semi-trucks. And it is claiming that Tesla's semi-truck, including the one, I think, that went cross-country in self-driving mode, infringe various design patents that Nikola holds. So very beginning of this lawsuit was just filed. We'll have to see what Tesla does when they come back and respond and fight this lawsuit. One thing that the coverage we have of this points out is it's somewhat ironic that Elon Musk finds himself facing patent infringement claims because he himself has spoken skeptically of patents in the past, and so much like we have been speaking about them skeptically on the show today. So the irony of him being in a potential patent infringing situation was noted by the IP watchdog piece that we have in our discussion points. You can see all of the stories that we've looked at to prepare for the show today. If you head on over to tagpacker.com/user/thisweekinlaw, and we are on episode 423. Anybody have any thoughts about very sleek looking semi-trucks? Alex?
I mean, from a very initial look, you can, again, I'm not familiar enough with, trucks in particular to say whether there is any existing other model besides the Nikola. If you look just at those two in isolation as they do in the article, I mean, it seems that one may have drawn some inspiration from the other, but I don't really know enough about the the market and the companies in it to really say. But I did have to read the headline about 3 times to make sure I wasn't saying Nikola Tesla sues himself. So that was but yeah, I think probably the most interesting outcome of this particular case may be, like you say, if it changes the attitude that Tesla itself has towards patents and enforcing them. That may be the most significant outcome of this particular case, but it'll be interesting to see where it goes, I think.
It will be interesting to see where it goes. I think when you get into the particulars of do they look similar, I think people have been noting the similarities in their appearance since Tesla started making trucks and debuted the fact that it was going to do that. So I think people have probably been going to the founders of Nikola since then, going, come on, you've got the patents, you've got to pursue this. So off they go. What Musk has specifically said on the subject, I guess in June 2014, he said that his business experience had taught him that a patent was simply a lottery ticket to a lawsuit. So apparently Nikola is cashing in its ticket. Matt, any thoughts?
Yeah, so just a quick point about the legal question is it a patent infringement? And unlike copyright, where it matters whether you're copying someone else, in patent law, if there's a patent on the books and you're you're designing the product that is of the same design, then you're infringing. It doesn't matter whether you've seen it or not before, which is why design patents are so. I don't know enough about it to like really be a skeptic, but like it just seems implausible, and it seems really much more like a trademark question of whether like the logical question seems to be like, are you confused when you look at that brand, look at the Nikola and the Tesla, and are you seeing brand differentiation that's leading to you usurping the market power of the other company? Which in a patent suit, that's not the question, but that's kind of what design ends up asking you, which we kind of talked about in the Samsung. So it's an odd design patent is an odd branch of patent law.
Yeah, it does seem, you called it trademarky earlier, and I see where you're going with that. It does seem like there should be a whole lot of overlap with trade dress, which is basically something's appearance. But a design patent is somewhat different in that it's the ornamental design of a functional item. So it's an industrial design right, and
which has been defined very broadly into Apple stairs and Apple buildings and designs of trucks that look modern. So like it seems pretty, that definition seems fairly meaningless.
Yeah. But it's not meaningless under the law. So we will see what happens with this one too. Let's see, what other patent stuff did we have to talk about? There's some good news for people interested in podcasts and who have followed along with Personal Audio's claimed patent that was invalidated in federal court in a last-ditch effort to keep legal consideration of that alive. A petition for the Supreme Court to hear the case of Personal Audio versus EFF was declined by the Supreme Court. So the Supreme Court's not going to take it up. The case is done, and the quote-unquote podcasting patent is not a thing. It was described as a system for disseminating media content representing episodes in a serialized sequence. So Personal Audio does not have that patent. And goodness knows, the way our patent system works, don't be surprised if someone else pops up with one that they claim covers podcasting. But this one, for the time being, is a non-starter. So that's good news, right, Matt?
I actually thought this one was not for the patent, but for the legal question that was presented. I thought it was going to go the other way. And this kind of followed the recent decision on the Gulf states, which upheld the AIA's patent system. But the question here was whether, or at least the question that was presented in the amici was whether the cert petition was whether whether you had to have standing in order to bring a challenge to the AIA. And basically, the Federal Circuit said that, and I'm just remembering details, but the Federal Circuit said that the EFF kind of got standing to defend the case after it was determined through the AIA, even though they wouldn't have had standing in bringing the suit in district court. So it is outside of the normal rules of standing, and it's just a question of, as a policy question, of whether it's good that anyone on the street can sue a patent holder to challenge their patent. It can be overly litigious, and it can, in this instance, get rid of patents that that would hurt us, or there's plenty of patents that are granted that should have been granted. So it can be a good thing, and it can also be a bad thing, because standing limits who can bring a suit, and oftentimes someone who can't afford to defend themselves in a situation would otherwise have to fold. So I was wrong on how it would come out. So, but I'm glad that we can still podcast.
Yes, I am too. And yeah, that's a really interesting question on standing because obviously EFF is not the patent holder and yet has great legal firepower and resources to challenge things like this. So I'm sure they get into those standing questions a lot.
I think that almost above 20% of the patents that have been invalidated have been invalidated by individuals or companies that wouldn't have had standing. So that's just been a major change in patent litigation since the AIA. So that's and you're gonna get places that you like the EFF, and you're gonna get places that you don't like that are doing this. So it's it's an open can of worms.
It is. Alex, any thoughts?
I think Matt's points about standing are hopefully, the more long-lasting, lessons and things that continue to be developed, as a result of this case. But I'm just so happy it's dead. I could never see, and I think most people would agree, I could never really see how personal audio had any real, legitimate interest or unique invention to really defend here. So I'm just glad it's gone.
Yep. All right, maybe we will use that as our first MCLE passphrase for this episode of This Week in Law. How about RIP personal audio patent as our first passphrase? We put these phrases in the show in case you are watching and listening and hope to obtain professional credit in your field by doing that. So if you're a lawyer in the United States, you can head on over to our show's wiki, which is at wiki.twit.tv. Find our This Week in Law page there, and there's a page about the various compliance bodies in the United States. I really can't even begin to get my head around whether this happens in places outside the United States or whether we would be able to help you with that. But in the United States, since we cover U.S. law, if you're a lawyer, you might want to use this as part of your overall suite of things that you use for your continuing legal education. And we have some guidance for you there as to how you might reach out to your compliance body and say, hey, I do this, and can I get credit for it? So that's there for you. We'll put another passphrase in the show. Some places like to have these validations that you've actually watched or listened and haven't just written it down on a list somewhere. Okay, so we've got our first passphrase going. I think we'll move on and talk about some privacy stories here in the last week before the GDPR takes effect. So next week, May 25th, that is next week, right? I think so. Today's the 18th.
Next Friday,
yeah, next Friday. The GDPR takes effect. So we've done a couple of shows where we've gone deep on the GDPR. Of course, if you haven't paid any attention to the GDPR, you don't know what I'm talking about. It at least has popped up on your radar if you are a user of online services at all in the last couple of months, as every single company that you deal with who also deals with the data of residents of the EU has been busy updating their privacy policies and terms of service and sending you emails that they have done so. So I don't know about you guys, but I've probably gotten 100 of those emails. And, must confess to not having read 100 updated privacy policies and terms of service. But I do know that it's all owing to the GDPR and to them giving further notices of what they do in compliance with those regulations that go into place next week. Alex, you're over there in the UK. Is there a lot of buzz about the GDPR taking effect?
So I must admit, I actually now live in Chicago, but I still know a lot of people Yeah, sorry, I don't like the accent for you. I still know a lot of people and companies in the UK, and I mean the UK is in kind of a slightly interesting situation because people hear GDPR and then they hear the EU and they go, well, we're not going to be in there, are we? And you go, well, no, let's leave that aside. As opposed to which laws you take and which ones you don't. It's got a reasonable amount of buzz, but I think it's still within the people who deal with this kind of stuff on a daily basis. I think if you go up to the average person in the street, even within the EU, they're not really going to know what it is or probably care. So yeah, it's probably about as much awareness as there is in the US of it, to be honest, from my experience.
Right. That makes sense. I mean, certainly here in the US, I think there is this overarching sense that we need to be paying more attention to things like privacy and the way we are tracked. But there's probably not, among people who aren't worried about the compliance aspects of this on behalf of their companies. There's probably not a whole lot of attention to what the GDPR is or what it means going forward. That it stands for General Data Protection Regulation, in case we hadn't made that crystal clear. One thing that I think people are going to see happen, I hope people are going to see happen, is we may see a shift away from this trend that we've had in several years of recent history of people being tracked and targeted so precisely. There is a really good piece written by Doc Searles over on his blog called GDPR Will Pop the Ad Tech Bubble. And I really encourage people to read this. And his lead-off point is he references the Big Short, where investor Michael Burry shorts the he calls it the mania and fraud-filled subprime mortgage market and makes a mint in the process. And Doc Searles basically thinks that analogy carries over to the advertising industry as we know it today, that its model cannot survive, will not survive the GDPR and the sentiments embodied by the GDPR, which are not unique to the EU. So Doc basically recommends, if you're picking horses in the investment scenario, not to bet on customers that are going to continue with this approach that we're going to track you and not care about how you might feel about that, not worry about the fact that you're not being adequately disclosed to, et cetera, et cetera. He says, do bet on any business working for customers rather than sellers. Bet on developers building tools that give each of us scale in dealing with the world's companies and governments, et cetera. So he really thinks that the advertising industry is going to have to rethink and reinvent itself, and goes into great detail in his piece, pointing out things like the fact, and we talked about this the last time we went deep on GDPR, that Google, rather than taking on all of the disclosure and consent obligations of its customers in its advertising universe, is basically shunting it off on all of its clients, saying, look, we're going to give you tools. You can deal with approved companies. We're going to give you a list of them to go ahead and do the compliance that you need to do under the GDPR. Or here's an option, don't track. We're going to give you that option as well. So advertisers and the people who hire advertising agencies are really going to have to rethink how they're going to move forward. Are they going to keep going the way they are going and do all this compliance? Or are they going to maybe back up and things are going to be less targeted, less personal? What do you think, Alex? You've got a bit of a marketing background.
I mean, I think few consumers and regular users of the internet are going to shed a tear for any of this ad tech to the extent that any of them really know that it's going on. I think most people still don't know they're being tracked and to what extent, but there's just too much money to be made here for this industry to just die off. I think a lot of us don't like the kind of practices that it uses today, but it's going to find ways to adapt that may be above or below board. I think some of these firms will just hope they don't get a high enough profile that they actually get enforcement action from GDPR. I think we're going to talk a little bit more about general enforcement in a bit, so I won't go too deep into that. But I just think that it's what, 220 pages of legislation, I think, and they're going to find as many loopholes through it as they can. There's far too much money to be made through all of the the store websites and tracking and targeting advertising that uses this kind of technology that and a lot of smart people involved with it as well. That I think it will probably have a bit of a PR hit when more people start talking about GDPR over the next probably couple of months, and then it will probably resurface back to the level that it is today, probably using some alternate tactics, but I don't see it really going away.
Okay, I'm hopeful, but I take your skepticism to heart. What do you think, Matt?
Yeah, I don't think it's going away. I mean, you look at in terms of advertising, you look at the alternative you have to doing tracking is, and I think this was pointed out in the article, you got to put news on the television, you got to put news broad-based. You're just not going directly to your consumer. And what tracked advertising or Google advertising, which is, they're going to get around this because they're going to say, look, we're not selling your tracked data. We're just putting the advertisements in front of the customers that you want. You don't know who they are, but and so what this is going to lead to is, I mean, the market's already centralized, right? So 65% of the revenue in advertising, online advertising, goes to Facebook and Google. They are all going to set up systems, and they already have the systems where it doesn't give you the data. So you won't have a Cambridge analytics system where you're giving out the data. You'll just say, we want to place these articles or these advertisements to these people because they're going to move this way, and that's how it's going to work. So I don't see you're going to get rid of maybe some the bad actors who are selling data all over the place, but you're not going to dethrone Google and Facebook with this.
Right.
You're probably gonna make them more of a duopoly than they already are.
Yeah, well, I'm not sure exactly the ramifications of this, but one thing that Facebook has followed other companies in doing, such as LinkedIn, is Facebook has an international headquarters in Ireland, and of course, it has its main headquarters in California, and it has. As the Guardian reports, it has moved the data management for all of its users outside the US, Canada, and the EU from its international headquarters in Ireland to its main offices in California, which means that those users will now be on a site governed by US law rather than Irish law. And I'm not really sure why that makes a big difference, because no matter what jurisdiction the data resides in, if you're collecting data about EU residents, you've got to comply with the GDPR. So, and again, this is all individuals who don't reside in the US, the EU, or Canada. So I'm not quite sure what this strategic piece is meant to do. Any better guesses than I have, Alex, about this one?
This was interesting. I mean, the way I looked at it, let's be honest, Facebook is one of, if not the main targets of GDPR, right? I mean, the amount of data that it has on people and the advertising it does with that is incredible. So, I mean, they're making an attempt like this to move themselves out of harm's way and still protect their existing business model. It's not too surprising. I don't see exactly how it defends them against GDPR, because like you say, they'd still be collecting data on EU citizens, but they must have some kind of argument brewing in the legal team within Facebook that says, well, if it's within a different jurisdiction, we can apply perhaps a lesser set of controls, perhaps. Mark Zuckerberg talked about applying the spirit of GDPR, but not all of the aspect of it, and I'm not sure how that works. Again, when you operate within the EU, as they do, and collect so much data on EU residents, but they must have a potential argument that they want to make, because surely they will be one of, if not the first company to be hit with some kind of enforcement action attempt under GDPR, and they must be doing this to prepare in some way for that. I just don't know exactly what their planned response is to that.
Right. What do you think, Matt? Any guesses?
Yeah, so my guess is that they're going to have some sort of opt-in provision that says I am a European Union resident, which you have to, if you're in the United States and your data is being held here, that you have to opt into that, which would make it by default that they can do what they want with the rest of the data. Which I mean, and you're also looking at, like, you're asking them to have take on 4% of their company's revenue and liabilities to keep their data in Europe. And, like, I'm sure the lawyers looked at that and said, like, all you got to do is move it to the U.S. and you've got the facilities, or you can build the facilities just to decrease that liability, because your risk is just too high. Like, right. I like that's a rational decision. In your 99% of your data of people in the United States are not European citizens. So, like, why are we going to have all of this extra legal risk for no gain? That doesn't make any sense from a business perspective. Now, whether if GDPR is what we want to go with the United States, then it seems like we should follow that law. Now getting in the other articles, it seems unlikely that Congress is going to pass something like that, and there's some ballot initiatives in California which could move the ball on there. But that's a lot of money. 4% of your revenue, like, it's unclear how that's going to come out. Is it sort of like the Apple Samsung case? Is it 4% of your revenue for breaching once, or is it 4% for breaching like all the times? Like, there's a lot of uncertainty, and I wouldn't advise my client to take on that risk.
Right. Yeah. A Reuters reporter named Sal Rodriguez tweeted, "Everyone 4 months ago, what's a GDPR?" Or actually, he tweeted, "What's a GRDP?" And then every PR pitch in May, GDPR is here. Need an expert? So
when I read this, I was just thinking,
GRPD is the Grand Rapids Police Department. Just to point that out there.
When I read that, I was just thinking, I wish I had the foresight, 3 years ago, 2 years ago, whenever they first put the draft of it out, to just come up with some kind of bespoke GDPR firm with some attorneys and some data security guys, and just a lot of the emails you get read like Y2K emails, if you remember those. People like, it's coming, you're all gonna die. And it's like, okay, we can fix it. Give me a lot of money and we're fine. So. Right.
It's definitely giving rise to a cottage industry, or maybe more than a cottage industry, in complying with it, as well as hopefully some rethinking of what this all means for how we do advertising, because it's been going down a scary road. And along those lines, California, you mentioned the ballot initiative that will be on the November ballot in California. Let me get the exact name of said law here before we go on. It is called the California Consumer Privacy Act of 2018. And there's a really interesting piece in the New York Times about the people who came up with it. For those who don't live in California and don't sort of live and breathe this every time you have a November election, we have ballot initiatives in California that if you get a certain amount of signatures, it goes on the ballot. So it's very much a populist kind of approach to lawmaking. And my take on this is, they've gotten over twice the amount of signatures they needed to put it on the ballot. So it's definitely going to be there. And what happens with these things is people who actually vote read it over. And if it, sounds good to them, protect my data, make sure that people are more accountable. Heck yeah. I don't think this is going to have any problem passing once it gets on the ballot, but that's just my guess. So the New York Times piece covers the really interesting trio of folks. Rick Arney, a finance industry executive, Alistair McTaggart, a 51-year-old real estate developer, and Mary Stone Ross, a former CIA analyst who worked on policy stuff with the CIA, and I guess told her they were all neighbors, and
wow.
I guess she said, "Yeah, I sort of know my way around government. Let's go."
Kind of.
Yeah, and so they took the approach that consumers should have the right to ask companies to disclose what data they've collected on them, the right to demand that they not sell the data or share it with third parties for business purposes, and the right to sue or fine companies that violate that law. Companies can still use the personal data if this passes. Companies can still use the personal data that they collect for their own purposes to sell advertising or to improve their products, but they wouldn't be able to sell or disclose that data to someone else for business purposes once a consumer has asked that not be done with their data. So it's not quite the GDPR, but it's an interesting twist on it. Various tech companies, including the big suspects you might imagine, Facebook, Google, others, have put some money into opposing the ballot measure. I'm sure as we get closer to the election in California, we'll see a lot more advertising and media around it. But again, the way that people treat these ballot initiatives is they get their ballot, they read the thing, they go, "Oh, that sounds good to me," and they vote for it. And a lot of them pass just because they said they are packaged nicely on the ballot.
And I thought it was interesting that the opposing proposition was that it was like the California Jobs Act, which is just like doesn't tell you anything about it either.
It's brilliant PR.
So it's just a battle of catchphrases over like incredibly important like for the economy, for your privacy, but let's just go with one-line phrases. That seems to work.
Right. And, we're seeing this with the GDPR. We'll see it if this initiative passes in California too, that if companies have to comply with these really complicated disclosure and consent requirements, they're not going to if they're going to put that whole infrastructure in place, it's too complicated to try and apply it just to one universe of users and not another. They'll put it in place across the board. So it becomes the tail wagging the dog, and all boats rise with that tide. So
it is getting a lot easier, compared to 5 years ago. It is a lot easier to segment your data groups into this. So I'm not sure that the effect is any more in technology. That it's going to be that if California passes a law that everyone else has to follow. There are you can design your web pages to show up differently for different people. So like having them show up differently and having different privacy policies in different privacy collections for California is really not that difficult. So I think that was true 5-10 years ago, that whatever California did, everyone else is going to do. I don't have any that's just an intuition that I don't think that's necessarily going to be true in the future.
Yeah, that's a good point. Our data management technologies definitely evolve.
I just want to say I really like the intent of this and what they're trying to do, but I guess my concern is, do you think, just us on the call here, do you think it would be a better use of everyone's effort to just try and align globally to GDPR and use that as a worldwide baseline rather than having, multiple homegrown efforts? I mean, you could have one in California, you could have one in New York, you could have one in, Britain next year, and it just instead of aligning around what could be a global baseline in GDPR. What do you think?
I think from an efficiency standpoint, that makes a lot of sense. I think from a practical standpoint, you're going to get people in the United States going, "I don't want to do what the French are doing."
That is true. Yeah. Yeah.
Or,
Sadly.
fill in your country.
It's a question of so it's efficient if the law is like well crafted and puts in good policies. It's really way more inefficient if it's not. So, it seems like a little bit of trial and error seems like a good thing. The first time I do something, I typically screw it up massively. So I expect the same thing of governments that driving towards a goal that you tinker with and work out policy flaws and that sort of thing seems like a better idea than just sticking something in there and running the whole gamut on there.
Yeah,
I think that's a very good point. I'm probably too early in ascribing a lot of value and success to GDPR because it's not even in place yet. So
I think
it's
it's 200 pages that no one's read, and we have no clue.
We have no clue.
At least we can admit it.
Yep. Well, we will soon.
Yeah.
Right. And remember, we've already likened it to Y2K a couple of times. That was just a big tempest in a teapot. So
yeah,
we'll have to see what happens here. What else? I think. There was one other point I wanted to raise on. Or just something to bring your attention to in our discussion points for the day. There's a great piece on Don Marty's blog titled, "This is Why We Can't Have Nice Brands." And this is something Doc Searles, who wrote the wonderful piece we highlighted earlier, pointed out that Don Marty starts out by talking about internet ad technologies, the sort of holy grail of them is to do things like reach the same user on mobile and desktop, use open standard persistent identifiers for users, connect users to their purchase history, reach the user that the advertiser chooses at the time the advertiser chooses. And it doesn't have to depend on the Google and Facebook duopoly. He points out that he's describing email spam. This is his quote. Every feature that ad tech is bragging on or working toward, email spam had it in the 1990s. So more to the point of, do you really, advertisers, want to be email spam in your business plan? I don't know. Maybe they do. Maybe they're why we have email spam in the first place. But I loved that he pointed that out.
I think they are.
So.
This reminded me of something briefly when you talk about targeted advertising and all this kind of stuff. Have you ever had an instance where a targeted advertisement you could tell was targeted to you based on one piece of information that doesn't reflect anything else about you, and it just comes off as wrong compared to if it were just a more general untargeted message? Have either of you ever had those kind of things that stand out to you?
Give me a specific example.
So I had a LinkedIn message.
This is going to lead to a funny story.
Yeah.
This just made me go. I was looking at my phone. I just went, what? Because this was from Procter & Gamble, I think. I don't know what they were trying to sell me, so it was completely ineffective. But it was like a LinkedIn in-mail message, and I could tell it was just based on me, just from my age profile. It must have been like, at the time, it must have been like 18 to 25 or something. It was only a couple of years back. And it was just the way it was written. It's like sometimes you get LinkedIn stuff through groups you're in. Like I'll get, oh, you're in wireless LANs. Would you like a wireless LAN training course? All that kind of stuff, or marketing. But this one was like, hey man, we know adulting is hard. And the guy sat there like typing it with his baseball cap on backwards. I was like, oh no. And he says like, hey man, you got to choose with his skateboard under his arm. It's like, you got to choose between paying the gas bill and getting those rare new concert tickets. What a bummer. And I was reading this. I was just like, you could not have turned me off of whatever you're trying to do any more than this. And I was just like, gone.
Oh yeah.
I don't know if you had any funny ones like
that.
So
what we really want to outlaw is bad targeted advertising.
Yeah.
Yeah. And it's gonna take a huge leap of faith and trust. I think one of the things that Doc Searles points out in his piece is surveys where if people are given a meaningful choice to opt out of targeted advertising, 70% of them do it. Only 30% opt to stay in. And if the industry hopes to increase that number, they're really going to have to show not just the value of the targeted ad and the fact that you're not just getting something that's a scattershot Hail Mary to you based on your age, as that clearly was. But, it's got to be meaningful and valuable, and we've really got to make it work. So they've got clearly miles to go. Yeah. Sadly, Alex, in your demographic, you're getting targeted to with things that are trying to, help you, I don't know, balance your busy life and be able to buy concert tickets. In my demographic, it's all about your the various ways in which your body is failing you. Or is about to if it hasn't done it yet. It's all about
I'll trade
fear.
you one of those for one of mine about how to do red skateboard tricks or whatever they're trying to sell me now.
Yeah,
I think Denise can do red skateboard tricks.
Once upon a time, I went down a ramp or two, and I probably shouldn't have done it at the time. I was too old at the time, but it did happen. I used to, at the very most, I can ride on a flat surface as long as there are no hills. I've never quite mastered braking at all, except for breaking the various parts of my body that the advertisers want me to preserve at all costs. All right. Let us move on. What else do we have to talk about? We have to talk about the Senate vote this week. Let's talk about net neutrality. Okay, so the Senate actually got its votes on this Congressional Review Act measure, where 52 Republicans, only 2 Republicans, but 52 senators voted to restore the open internet rules that are going to go away next month on June 11th. When the Ajit Pai's Restoring Internet Freedom rules replace them. So lest you be too enthusiastic that, now we've got net neutrality back again and we don't have to worry about it at all. That's not what happened here. We had one portion of Congress, the Senate, pass a resolution that says that we would like to restore open internet rules. For this to do what it has the potential to do, it would also have to pass the House, and then it would also have to be signed by the president. And those other two things don't appear likely to happen. The House doesn't have the votes to do it. The Senate didn't think they had the votes to do it, but they had 3 surprise Republican senators. Senator Susan Collins of Maine, who I guess they had thought they might have her vote, but then John Kennedy of Louisiana and Lisa Murkowski of Alaska waited until the day of the vote, Wednesday, to decide to back the resolution. So in the House, the votes are far more weighted against the passage of this kind of thing. So the House doesn't seem likely to pass it. And of course, the president doesn't seem likely to sign it. He has already made statements that he supports Ajit Pai's approach. He appointed Ajit Pai. So the whole thing is really more theater and posturing than anything else, and really lining up where do you stand on this issue for the upcoming midterm elections, because among the folks in your demographic, Alex, and maybe even younger and or slightly older, this is a very big deal. And politicians in the United States know that if they want to reach those voters, this is something they need to be talking about, and they need to be appealing to them on this issue. So what do you think, Matt? Any substance to this? Anything other than campaigning, really?
Yeah, and I think that I think it's campaigning in the best way. It's a big issue that people seem to care about, and an election's coming up, and that's what the elections are there for. So it's whether you like it or not, it seems like a good. Like a much better debate than what we've been having about how our internet is going to work. It seems like a great debate. It'd be really nice if our politics could focus on more things like that. So I think this is great. But yeah, it's not going to pass. So
it passed the Senate, and the Senate is happy. The senators who wanted to pass it are happy about that. But don't expect it to go further. Alex, any thoughts?
Really, just echoing what Matt said. Really, I mean, I think it's good to always have more discussion on such a complex and I think often misrepresented issue as this. But I don't think this changes the next destination for it. Really, so
right. One of the pieces, and I have, of course, all my tabs open to do the show, and I'm not quite sure where I saw this quote, but we keep saying, don't freak out about net neutrality just yet, because even though the open internet rules are going to expire, well, definitely freak out to the point that you want to, be vocal with your representatives on the issue and let them know how you feel about it. But if you're thinking that everything's going to change on June 11th, it's probably not, because I think that every service provider wants to see some certainty on this before they make huge investments in marketing and strategy designed around having a non-open internet. But the quote that I was that caught my eye is just making the internet look more like a cable company with bundles and packages that give you access to things. That really. I get enough of that from other aspects of things that I subscribe to. Really, really frightens me that kind of situation could apply to the internet. So, definitely keep the issue in your thoughts and on your minds as you get ready to let your representatives know what you think, and let them know what you think when you vote. Let's see, what is our last thing? Let's talk about AI-generated music. This is a topic we've talked about before on the show in the context of copyright. And I think that's why, still we would follow it and try and decide how copyright law is going to work when a human creator is not the person doing the creation. The reason we do an animal selfie of the week every week is because courts and the U.S. Copyright Office have had to consider the issue of what are the rights of a non-human in a creative work, and still remains, even though the Copyright Office has spoken on that and said a non-human doesn't have rights, it remains an open and interesting question in other ways. That's why PETA brought its lawsuit about the monkey selfie in the first place. So we've talked about the fact that AI-generated music has been coming along for a while. This week in Wired, Matt Janser highlighted some examples of exactly what's going on in the world of AI-generated music. Has several services that he highlights. One is, for example, something called Lander that automates the audio mastering process, which actually isn't creating the music, but I think this is a wildly interesting and useful technology. The AI compares nearly finished tracks to a database of 7 million already mastered singles and tweaks each song based on previous adjustments. By processing the tracks as a batch, Lander hones a unified sound. So I'm sure there are audio engineers listening to this just going, what? No. But maybe that could be really useful as well. My favorite of these examples was created by something called IVA, which stands for the Artificial Intelligence Virtual Artist, which combs through the works of composers like Bach, Beethoven, and Mozart, and uses the principles of music theory to make predictions and generate musical models. It was developed by computer scientist Pierre Barreau, and it reconfigures those models into an original piece and arranges new sheet music. So the author here called out a track called Among the Stars, which I see we have queued up. Let's listen to that. So I don't know about you guys, but I think this is pretty great.
Yeah.
Yeah.
It's very impressive.
Can you, if you haven't read the article, you probably both have, but I'm wondering if our listeners can guess. I'm going to look in IRC. Who can guess what composer that was supposed to resemble? Anyone in IRC want to hazard a guess? No. Going. Pleasant sounding meanderings. Yes, it definitely, once I say who it's supposed to sound like, you'll get it. You'll go, oh yeah, John Williams. Because that definitely had some Star Warsian notes to it as far as I was concerned. But I thought it was really interesting, complex, great music. Jerry Goldsmith. People in IRC are saying, or a Game of Thrones vibe. Yeah, it's NAI. And there are various other examples called out in the article. And I guess the reason that I'm bringing it up, and my former co-host, Evan Brown, is the one who spotted it. That's where I saw it, is in his Twitter feed. The reason I'm bringing it up is because I think this has come a long way from where we first started paying attention to it. It might be worth listening. There's another tool that's called out in the article. It's created by Sony Computers Science Labs. Flow Machines is the name of it. It analyzes tracks from around the world, then suggests scores that artists interpret into songs. Its debut album is called Hello World. It also, for that, I guess, surveyed syllables and words from existing music to create original, sometimes gibberish vocals. So let's play a bit of that Flow Machines product. This is a Beatles-inspired song.
This is very Beatle-esque.
Mm-hmm.
It turns me on.
I don't know. It could probably use some work on the lyrics front. Pretty cool. Anyway, yes, continues to flow along. So, we've covered that story of the guy who is suing because he generated the computer program that makes all the CGI characters in things like Marvel movies. And this strikes me as fertile ground for those kinds of claims. You would certainly, if you were a musician, want to pay attention to what sort of rights you have if you are using one of these tools to help generate your music. What else, Alex? Do you have any thoughts?
To me, this is just such an interesting step in the creation of music, and you see similar things happening even with things like with writing as well. With these neural networks, like people will feed all of the material that's ever been written for Harry Potter into it, and it spits out another book, and it's strange in some ways, but then parts of it kind of make sense. And like these songs, what's so striking about these songs is, at least to my ears, they are good enough that you could put them on and people wouldn't go, but that's obviously not made by a human. They're actually good. And it's like, especially the classical one, you could put that as a background music on anything, and I don't think anyone would really bat an eyelid. So it got me thinking about, if the AI creates 90% of a song and I then finish up the remaining 10% with some tweaking, do I still have all the copyrights to that song, or do the creators of the AI have some right to that? What if the AI does 99% of the work? What if I just click a button, the AI generates the whole song, and I just publish it under my name? What if you make the equivalent of Thriller under that, and people want to come after you? I mean, I don't know if our copyright system really has any concept of that, and I'm sure it's something that's going to get more contentious as the technology progresses. And I'm just hoping that people don't get sued by Hatsune Miku anytime for the use of her vocals. She's the the Japanese virtual pop star with a voice synthesis engine, so that one can't be too far behind.
Right. I was just thinking that somebody soon at the Sundance Film Festival is going to submit a creation that an AI generated the script, all the characters are CGI, and the music is produced by one of the AIs we just listened to, or something similar to it. Any thoughts, Matt?
Yeah, just only that these musicians are only slightly better than me. But I think and it's also like, what's the copyrights of someone whose music is being drawn upon, right? So this music was clearly drawn from the Beatles, right? Is that infringement to be aggregating, not just one piece of music, but multiple pieces of music? The test for originality and copyright has to do with it's premised on a human concept of originality, which is more than a scintilla. I think that's how I always screw that word up. Scintilla, yes. But I love the idea of that word, but I can never pronounce it. It's horrible. But anyway, so that is, that's the test, and it's a human-based test, and there will likely be some interesting developments over the coming years, because you're working in a world where you think of humans as taking in small amounts of data and copying based on small amounts of data, but what computers can do is take massive amounts of data and output various different performances based upon that. It's just a different it's a different way of organizing concepts and ideas, and the law is going to have to adapt.
Right. Well, I think you raise a really interesting point, that what are the rights of someone whose works inspire a work created by an AI? Because this is something we're seeing played out in the music industry with real life flesh and blood artists. A lot of the music cases that we talk about on the show have to do with that. The Blurred Lines case, where the Marvin Gaye family prevailed against Robin Thicke and Pharrell Williams for copying that Marvin Gaye song. And it was all about the vibe of the song. I forget exactly the legal terminology, but sort of it was clearly a question of whether the Marvin Gaye song inspired the second song. And so,
what if I take all of the music from the 90s and make a song based upon that? And, it's the same sort of question as the 200,000 patents that go into a phone, and then you have one that's infringed, right? So you're the Backstreet Boys, and, a couple of your songs were put in this algorithm. So is that copyright infringement? One? And yeah, because I took from it. Like, you had this work that was copyrighted, and I admit that I took from it. And then two, what's the damages on that? Right. All of it? Because you're only one of the songs of the 90s, although very influential and clearly brilliant. But what do you do with that? I'm not sure.
Right. So yeah, this Marvin Gaye decision could definitely put these AIs in the crosshairs if they're borrowing too closely. If you can really nail the fact that, oh yeah, that's supposed to be John Williams, they might have some legal issues around that. All right, let us move on to our concluding material for the show. We bring you for the second week in a row for our animal selfie of the week, a creative work by YouTuber Viva Frei, who, or if I'm saying Frei, who also was responsible for last week's squirrel video. This week we're going to bring you inside a giant tarpon. And I will say right at the outset, this is the kind of animal selfie where the animal isn't involved in taking the photography at all, except for maybe, there we go.
Oh my gosh.
Except for maybe, I don't know, are you involved in the cinematography if you eat the camera, which is what this tarpon does.
Oh my
Look
gosh.
at those gills, right?
I don't want my hand in that.
I'm just glad this isn't in VR. I don't need that experience.
Right. So here we go.
He is very excited, though.
Super slow-mo. Whoa.
Wow.
If you ever wanted to gaze out the gill of a tarpon, Viva Frei has given you that opportunity. So he's got a bunch of good videos. Tip of the week. This is a tip that comes my way from Jonathan Annett, one of our regular listeners and emailers. And this is a great piece that he called out way back 2 years ago in 2016. Governor Brown here in California passed a law that closes the Steve Jobs loophole as far as needing to put a license plate on your car. Apparently, I didn't know this until I read this article. Steve Jobs was famous for refusing to put a license plate on the back of his car. He had a Mercedes-Benz SL55 AMG, and what he would do was a series of leases. So because there was the loophole was you had a 6-month grace period after you'd gotten your new car, during which you didn't have to have a license plate on it. So as soon as his 6-month lease was going to expire, he would get a new car and then he wouldn't have to put the license plate on again, over and over and over again. So Jerry Brown back in 2016 decided, no, we're not going to let people do that, and passed a law that is going to go into effect as of January next year. So if you're a person who lives in California and just hates putting driver's licenses license plates on your car, or you're a particular fan of Steve Jobs, and this has been your personal homage to the great man, you're going to be out of luck as of January 1st of next year, because that loophole will no longer exist. You're going to have to, California is going to join most other states at that time by requiring newly purchased cars have temporary license plates, and will create a system that allows car sellers to report the details of the sale directly to the DMV, including the date of the sale and the names and addresses of the dealer and purchaser. So you've got until January next year if your 6-month lease has not yet expired.
You're gonna have to move on to filing patents on buildings for your homage.
Yep.
To Mr. Jobs.
That's right. And our resources of the week have to do with our earlier privacy discussion and GDPR Day coming up next Friday. Customer Commons has declared that GDPR Day, May 25th, should have a more festive name, and they're calling it Privemas, like Christmas. Privemas, #Privemas. So that is something to look out for. Do celebrate and follow that hashtag next Friday. But more concretely, as far as a resource goes, and again, this is in connection with that day from Customer Commons. What Customer Commons points out is that most of the cookies that follow you around the web are not planted by the sites themselves, and they actually go back to Lou Montulli, who invented the cookie in 1994. And he says the goal was to create a session identifier and general memory mechanism for websites that didn't allow for cross-site tracking. So the harmless purpose and beneficial purpose of a cookie was to help a site remember that you've been there before or that you have an account with a shopping cart. That has given way to the raft of third-party cookies that also function across the web, that are planted for marketing purposes, and they mean to track you around and ostensibly give you relevant or interest-based advertising based on things like your age. So if you go to Customer Commons, the other thing that we're going to see a hashtag on starting now and continuing on is hashtag no more thirds. And we have the link in our discussion points to their page on how to block third-party cookies. They have instructions for every conceivable browser you might be using. So if you want to go and block your third-party cookies, they've got you covered, and we'll show you how to do it. Any thoughts, Alex?
I think it's a great idea. I'm not sure that Privamus or Privamus will catch on in any meaningful capacity, but I think anything that can, educate people and give them protection against, the mechanisms that all of these companies use to collect all this data on them and track them around the internet is a good thing. So I hope it gets a lot of traction. I don't think I'll be seeing a lot of people talking about Privamus, but GDPR maybe. So hopefully this latches onto that. And I think it's good. It's positive.
We're talking about it now, so
good point.
trying to get the word out.
You need to find a better set of friends that are willing to talk about this.
Next Friday, everyone I encounter on the street, hey, did you know it's Privamus?
Yeah. What do you give for Privamus? What kind of token or ornament do you give?
A cookie, of course.
Yes, you give harmless cookies is what you give.
Or a super cookie.
or a super cookie. Oh, I love it. Okay, one other thing in which you can become the resource for a worthy cause. Actually, it's not a worthy cause. It's really just humor. But I mentioned Devin Brown, my former co-host. He tweeted out a few days ago, just wondering if anyone has been preparing a Don McLean parody /cover for the day when Ajit Pai steps down. And one of his commenters there, Adam Sanders, came in and wrote the first verse of the Ajit Pai version of American Pie. And do you believe in net control? Can Tidal 2 save your soul? Or do you like your bandwidth real slow? So
well done.
Oh, thank
Beautiful.
you. No, that was awful. So if you can go add a verse. We need this to happen. Fetch needs to happen here.
Can we have an AI sing it and create the music?
Oh, we should. Definitely better than me singing it. But as far as creating the verses, head on over there and help write this tune that needs to be written. Be that resource for Evan. I encourage you. And it's been really, really fun getting together with you, Alex. Thank you so much for getting in touch.
Thank you for having me on. Very good. And I hope to come back sometime, if you're not all sick of me quite yet.
No, we're not sick of you at all. Did you ever resolve whether you're going to have to attend four-year university before you can attend law school?
It's pending with LSAC at the moment because it's a delightful combination of a master's and a foreign master's. So they're chewing on that at the moment to figure out exactly what it means. But in some good school-related news, I just wanted to say it's going to be a little bit crazy here over the weekend because my wife is graduating from nursing school tomorrow. So very proud of her there, and it's going to be good.
Yay! Congratulations to your wife. That's wonderful. How long does nursing school take?
I think it's about 2 years. I'm going to get that wrong, and she's going to hit me when I get off this. But I think it's 2 years, maybe 3.
As long as you don't say an eternity, you're good.
Right. Oh, my goodness. Well, we appreciate your putting yourself in personal jeopardy for the good of the show, Alex.
Threw him under the bus there.
Anytime.
That's right. All right. Well, I really thank you so much for reaching out and for joining us today. Matt, wonderful to chat with you as well. So glad that school has wrapped up, and good luck with the move and everything else.
Thank you. Things are going well, and I'm probably the only person with a startup who actually has more time now that I just have my startup rather than school and said startup. So I feel like I have freedom now. I probably shouldn't tell my investors that, but
Right. Okay,
well.
you've copped to the fact you have a startup. You've copped to the fact you're getting funding. Can you tell us any more about what it does?
Yeah. So I mentioned this a couple weeks ago, but it's Pareto Life Sciences, and it is we connect patients who are suffering from leukemia, lymphoma, and anemia with donors who we compensate for their stem cells. So we sign up donors with a buccal swab, and then when a patient needs leukemia, we facilitate the transplant. So that's what we're doing, and we've got good traction. We've got people are very excited to join and to help save this, and it's a donation process similar to plasma donation, and so you just have your stem cells extracted through your bloodstream. It's only adults, and yeah, you get paid to save somebody's life. So it's a pretty good deal.
Wow, that's wonderful.
Fantastic.
Yeah, best of luck with it all, and definitely keep us in the loop. Let us know what's going on with Pareto Life Sciences as you go through. You could star in your own version of Silicon Valley in a way. Silicon Valley Life Sciences, like all the spin-offs of the CSI franchise.
I don't think so.
No.
I've never even watched Silicon Valley, so now apparently I need to.
It's funny, but it makes me cringe more than I like to.
Okay.
I haven't watched much of it either.
I'll stick to watching Psych, which I'm totally addicted to.
Yeah. All right. Well, wonderful. Kudos and congratulations on all that great stuff. What are you going to do about school next year?
We'll see. Hopefully, Notre Dame has given. They have 7 years in which you can finish. So.
Oh, well, that's great.
We'll
Awesome.
We'll work something out.
Cool. All right. Well,
I'm going to send Alex for me. That's the better idea.
Do what with Alex?
Degree, Alex.
Send Alex to school. There we go.
Yeah.
He'd love to jump into Notre Dame with 2 years already under his belt.
Yeah.
Just have to do 1 year of school.
Yeah.
That may have some unintended consequences for you.
All right. I'm a fan of unintended consequences.
All right. So glad that you guys have joined us. So glad that our audience has joined us today. We're just thrilled that you do tune into the show, and that some of you go on to decide that you actually like the law after listening to our show. That's really, really cool. We do the show every Friday at 11 o'clock Pacific time, 1900 UTC. So we're thrilled if you can join us live. That's great. If it works, you can jump and chat with us, interact with us during the show. But don't worry about it if that doesn't work out for you. We always post these shows to our website at twit.tv/TWiL. Our whole archive of shows is there, as well as instructions, directions, suggestions on how you might want to view the show using whatever technology or service you like the best. So we're there for you in all manner of ways. We're just glad you're there for us. Please do get in touch with us between the shows. You can email me. I'm Denise at twit.tv. Matt is Matt C at twit.tv. Mike Keys, who's not here this week, is Mike at twit.tv. He should be back with us next week, I hope. What else should I tell you? Told you to email us. You should also let us know in that email, or just as you're vagabonding around the web, blocking those third-party cookies, that you have seen something that you think that we should pay attention to. So if you're on Twitter. You can get in touch with us there. If you're on Facebook, you can get in touch with us there. Whatever you spot, just drop us a line or an @ or whatever to let us know you think that might be worth paying attention to. We really appreciate it and get lots and lots of great tips from our listeners to this show, as well as people that you have come across in your reading or viewing or what have you that you think might be good guests on our show. We have no fear or shame at all about reaching out to anyone and asking him to come on the show. So, if you think we should take a flyer on someone, then we'll do it. So let us know that too. And until Privemas next Friday, that's it for This Week in Law. We'll see you then. Take care.